for being Hey, computer people. We appreciate you guys being here so much. As Robert said, we've got Dawn here to talk to you on the contract changes, on PIDs, on any questions that you may have. Georgette and I were talking a while ago about Dawn's tip of the week. If you guys are not getting her tip of the week, text the word title to 313131, and you'll get that on Thursday afternoons or Fridays. And each week, it's something that's definitely relevant to the business today. But if you guys have anything that you're kind of struggling with, or you would like to hear her speak about on one of those podcasts, please email me and let me know. Or if you think about it today, write it down, and we'll get with our corporate communications director and make sure that that happens for you. We've got Fair Day coming up on the 28th. Who else going? Who needs a funnel cake and a corny dog? I do. So we're going to the fair together on the 28th. So I can't wait to see you guys there. Other than that, thank you all. We've had a very busy summer. Closings at Allegiance down here in Coppell, and we really do appreciate every single one of you. It's been fun seeing you at the closing table, and we look forward to seeing you all very soon in your next transaction. So I'm going to go ahead and turn it over to Dawn. If you have any questions, this is going to be very informal, so please ask away.
All right, so glad to be here. Before I get started, I wanted to introduce another attorney in my office, Blair Raggio, who actually happens to be my daughter too. But she is an attorney and has an MBA from SMU, and she went to a law practice for a couple of years, and then I begged her to come into my company and help me. And the beauty of it, the sad part for her, she came right before COVID, but the beauty of it, this office was her first place where she came and attended a presentation with me before COVID. And she got to meet Kay and some of you here, and she's been learning through Zoom and everything. And now she's really taken the ball and running with it. So I can go on that Danube trip with you and Mark, okay? I do want to mention that I was told very specifically that I have boundaries up here. The chair is the farthest I can go, and this is I can go. Part of it, Robert knows that I do like to talk like this and walk around and talk to people. But I also it made me think, I wanted to share, if anybody read any of those boundary books, they're very popular. They're boundaries with your team, boundaries with your spouse, boundaries, they're just called boundaries. Well, it happens to be a guy who went to school with my husband at SMU. Never known he would have become so famous. But the Boundaries book is a psychology book that everybody reads. If you're raising teenagers, you read Boundaries. And so we were at some place visiting some mutual college friends. He wasn't there. And someone just said, well, that's Henry Cloud's yacht that just went by. I said, well, okay, so we're all in the wrong business. Write books, pretend that they're relevant, and then we can be famous. Actually, you all asked me to come and talk. There's two topics that I'm going to specifically address. And then I told Kay, but it's not easy to tell you what to do. The first topic is about the new Public Improvement Disclosure District notice that requires that new contract, and then you have a new addendum. I'll talk about that. Interrelated with that, then Mark says, well, of course you need to add about MUDs and water districts and everything else that we're all confused about. So since Mark called me 2 days ago, I had to study immensely because it's not easy. And then the next topic is the new laws with regard to the Property Owners Association. And I've done a couple of videos on this new law, which your Texas Realtors did magic this session to help you, but I'm going to tell you how they're getting around it. But someone pointed out to me in my video, I didn't make it clear. What I need to make it clear when I talk about this today is for single family homes. It's for managements and homeowners associations on single family homes. The condominium has not been covered yet by this. But partly it wasn't until we got those property owners associations, that's really what they're called. But if I say POA, you think power of attorney instead of property owners association. So I slipped into HOA on that. But we didn't have these problems with condominiums until these single families came, that we were having to pay out the gazoo for information from them and for all the transfer fees. So anyway, this is really to regulate the single family home management companies companies and associations that I'm going to talk about today. But first, more importantly, let's talk about the public improvement district disclosure. The law now requires that the seller give notice to the buyer before execution of the contract that a public improvement district is imposed on the property that he's selling it. So if it's residential property, must disclose it in writing. The recourse of not disclosing before execution of the contract is just like your MUDs, just like your water districts, is the buyer has the right to terminate the contract at any time if you didn't give notice before you execute. The one question that I get is how much time once you give the notice do they have? So let's say I didn't give it when I executed the contract, but I gave it the day after I executed the contract. How much time does the buyer have the right to terminate? Because like on a seller's disclosure notice, you only have 7 days from the date of receipt. Laws, it doesn't give you a limitation. So if you get it, if you provide that notice after you execute the contract, the buyer would have that as an out all the way up to closing. Okay. Now, that's the only recourse for not giving that notice, that MUD notice, that water district notice, the public improvement district notice, because the public improvement is the new one, but it follows exactly what they are. That's the only recourse for not giving it before you execute the contract. Then, though, all of those laws require another notice to be given on or before closing. And it has to be signed by the buyer and signed by the seller and recorded with the deed records. Now, if no notice is given then we all have liability. And there are some significant damages, the main one of which is this: they can rescind the sale or rescind the purchase. The seller has to buy the property back. Okay. I have never, ever in my history, and MUDs have been, the law with regard to MUDs has been out there for a long time. I have never had a lawsuit over that. Okay. I will also tell you with MUDs and water districts, rarely have I ever seen agents give the notice before execution of the contract. It's usually done at the closing. Okay. And I've rarely had a buyer, so let's say you didn't give notice ahead of time, so the first time they come to closing, when they come to closing, the first time they get the notice, they would have the right to terminate the contract. But I've never seen them terminate the contract under that either. Once they sign that notice and once they close, all penalties, all ramifications are gone. Okay. Now, for those of, so because these penalties are so harsh, everybody goes, oh, this is kind of scary. But if they understand it's just like what the MUDs are, and you've been experiencing the MUDs so far, and I don't know that you had any come back on you if you haven't disclosed it, the title company just didn't disclose it to this day, and there's very short statute of limitations for them to come back to you after they discover this MUD or this PID on the property. Okay, so now what the problem is, or the benefit, the good thing on the PID notice, the public improvement district notice, you don't have to fill out the tax rate and the bond and all of that like you have to do with the water districts. And the PID isn't different if it's in a incorporated municipality or an incorporated municipality or the extraterritorial jurisdiction or it's in a county. I mean, there are different ones for MUDs and water districts depending on where the property is located in an incorporated municipality or the only thing like on some of these is how much property, if for instance, Hop Hill was part of a MUD, but the whole city was part of that MUD, this doesn't count. It's if it's less than 75% of the city. You guys aren't going to follow that much. Back to the PID. PID doesn't have to disclose bond rates, all that. The PID disclosure is pretty darn easy to do. The PID disclosure, I've got a copy of it for you. This one is done as an addendum to your contract. Now, I have mixed feelings about this because this isn't a this document as an addendum to your contract is not a promulgated addendum, meaning it's not an addendum that you must use. if the PID has notice, which they're supposed to file of record, they just have a period of time to do that. Once they file their notice of record, you can just pull that notice and give that notice, and that's sufficient. So you don't have to follow this addendum. The reason commission created this addendum for you is so that you knew what information was required in that notice. In this PID, all you have to do, there's some things you have to do. You have to say, you have to give the property address. Well, that makes sense. You have to say what jurisdiction did it. Was it municipality or was it the county? The only, and then you say, well, then it could be changed by at the next city council meeting or the county commissioners meeting. I mean, those are the only choices there. If it's in the city council, if it's commission court. The only place that people have a concern about is there's a provision in there. If you look at it, you have to say under what chapter of the water code, of the code. And that it says chapter A, subchapter A of chapter 372 or 382, and everybody goes, I'm not gonna know which one it is. Well, generally, once you find out if it's in a PID, it's really on the face of it, it'll tell you. But in reality, there are only chapter 382. Someone who's done a lot of legislature, they'll understand. It was a carve out for certain counties of certain sizes and certain demographics. And it's only right now, only applies to counties. There's 3 counties around the Bear County area, then San Antonio that applies. It's a certain size, certain demographics, blah, blah, blah. So, but I'm going to tell you today, if you have a PID that you need to disclose, where you disclose that chapter 372 or 382, default to 372, because probably it's going to be 372. Okay?
John, you said this wasn't promulgated.
But that is not promulgated. So that's why I said that's a little bit of my problem. They did, it's not promulgated. It's approved, but it's not promulgated. You can use any notice that complies with the law. My problem is they created this as an addendum. Now, what happened is the commission has the authority to approve contracts or addendum on an emergency basis. So it doesn't go through broker lawyer committee. It doesn't go through comment. It doesn't go through comments through broker lawyer committee. They can approve a contract or an addendum on an emergency basis for your use, but they still have to follow the regular promulgation process. So actually the contract that they approved on an emergency basis, if you look up in the right-hand corner, you see 11/8/2021. You're not even there yet. So I've had some people say, wait a minute, I can't use this contract because this isn't even effective yet. It's effective by approval. Arguably, I don't know that they've actually even repealed the other contract yet, but it's an approved contract and they pulled the other one down. So this one's approved. Arguably it's approved. That means you wouldn't have a problem if you used another approved form. It's just they're not providing you another approved form. So basically you got to use this, but this is still subject to comment. This contract is subject to comment. Where it will be promulgated is on November 8th, 2021. Now, that was a long story to get to you why I don't like the fact that this is an addendum notice. We don't have any other thing in paragraph 22 that is just a notice. But paragraph 22 lists your library of addendum. And you know your MUD notices are required, but I don't have that as an addendum. And actually, we steer away from you adding to the contract as an addendum to the contract notices, because notices are just notices. They're not there to change any contractual obligations between the parties. That's what your addendums do, you know, like sale of other property. I don't have to close if I don't sell. So those are contractual obligations. So the fact is, I don't really like this addendum being part of the contract, even under and I'll tell you where it comes from. But so I'm concerned about that. But they did it because they needed you to know what you had to require for the notice. But it is only an approved form. And I'm going to submit to you once the PIDs start filing their service plan that is required by this new law, they have to file the notice with the service plan And you should use that notice instead of filling out. I know, it gets worse. So let me finish this. That's why I say this contract is up for comment. So I'm trying to encourage a little bit of comment. Why did we have to have this contract? Why did we have to have this addendum attached to it? It's only a notice so that it's mandatory. Where it came is actually it's 6E7 of the contract is what had to be changed in the contract to make this effective. So you can see under 6E7, there used to be a longer disclosure about what kids and the opportunity. This one actually says you have to go to a notice, but then it says an addendum is required. You don't see that on the mud. You don't see that on the water districts, that an addendum is required, a notice is required, but not an addendum. So I think this have I confused you yet?
Yes.
Okay, so do you see why I'm not sure that this contract isn't worth commenting to? But I do know why they did it, is because it's new, and you had to be able to provide the notice, and you had to fill it out and give the notice. Now, when MUDs came into being, the law was the same as this, and they've been in business for a while. You guys didn't do the notices very well. It was always really done at closing. Houston has them all over the place, and they do it all the time. They're used to it. The real crux of a PID, a MUD, a water district, the real intent behind the statute of the notice is to give notice that a buyer is taxed for these things, okay? And so some of these, I mean, all of them, if you're being taxed on them, will show up on your tax bill. Okay, so you need to look at the seller's tax bill. And unfortunately, you guys, if you look at your tax bill, you know, in the county bill, you've got the hospital district, you've got you've got several districts in there. If you see a PID, if you see a MUD, if you see a water district in there, you'll know that this is there. If you don't see one of those, then where else do you find it? And really, do you need to? Yeah, I mean, you probably need to see if the seller knows anything about it. And there are websites. Mark did some good investigation for you on some websites. You can look at that. But I'm going to submit to you, if there's not a tax on it, probably not a whole lot of ramification if it was there and you didn't do it. There is safe harbor under the law about all that liability to you and me and the seller for not giving notice if we give a copy of the notice that was filed in record. That's what it says. And they're required to file a record. Well, if we can't find a record that they filed it. So the law sounds very extreme, and it is, but it's no different than what we've been dealing with MUDs and the other water districts. Now, Mark had conveniently created a form, or you guys had created a form on your forms that you could use for these water districts and MUDs to disclose. The problem, and to make it easy, which was great, that's kind of what Grover Lawyer Committee is trying to do, or Commission is trying to do by adding this addendum. But to be honest with you, that won't work for your water districts or MUDs technically. It'll be good enough to give you notice and at least get you started. But there are 3 different forms for a MUD district. And there's other different forms depending on the water district. And again, it's so complicated. You read the statute, it's so complicated. But it gives you that out. They're supposed to file it a record. And you're supposed to be able to get it from them on the PIDs. On the water districts, they're supposed to have it available for you. And if you make, it's in the statute, if you make written request for them, they're supposed to give it to you. And that's the notice that by default, if you give it, you have the right to give what you were given by them, even if it's wrong. You know what I mean? Like that. Business gets harder and harder every day on these disclosures.
Well, I have a house listed in Vista Ridge Estates, and it has the levy improvement district. That doesn't sound like a PID, but it's not really a water district either. It's a PID.
Right.
It's a levy
It
improvement
may be
district.
a public improvement district, and is it taxed?
It is taxed, and you can look at the Denton County appraisal
Appraisal
district and see the exact tax and the exact rate. and everything.
Then you better disclose.
So do I use the notice to purchaser from the lid, or do I use the PID, the new PID form?
I would use theirs.
Okay.
Because this again is not promulgated, but also if they have it available, to pull that, you've got all sorts. Because your release of any kind of liability, you can give that form. If you build this one out wrong,
Mhm.
you have liability.
Okay, well, I don't think they have an exact notice to purchaser. What they have is a paragraph outlining all those things.
So they
Like,
don't have a, they don't
they
have a
don't have,
signature on it.
I don't think they have one that they've signed, but I do have the one that was the notice of record that they filed with the county.
That's good. That's,
And so I can add sellers and buyer signatures to that.
that's the notice. Yes, let me tell you, the problem with this whole law, it was effective September 1, so you have to comply with it, but the service plans don't have to be filed yet that have those notices.
When do they require to be filed?
Once a PID is approved, by ordinance or county commissioner, they have to file it within 30 days of that, and they have to file the notice with their service plan. But if you're a PID in existence now, which is really what you guys are dealing with, is they have until the next required service plan to bring it up to conformity with the notice. And that next service plan may be a year.
And where do you get a service plan?
That has to be a record in the deed record. So the service plan is in the deed record. But some of them don't, we haven't even filed those yet. So
So
the-
we call our favorite title company? to
you can
pull it,
call your
or-
favorite title company, but this is where I want you guys to go, is go to your seller's tax bill. See if you see an improvement district, any kind of improvement district, mud district, whatever. Then they're supposed to have websites. The PIDs, it actually literally requires a website. They're supposed to have a website that you'll be able to go to. And to be honest with you, how does the title company get it? We call up the mud district and we get the information from them. That's how we do it, once we see the tax certificate. So everybody says, well, we'll just rely on the title company because they have some special magic. You do, yes, exactly.
Yes.
We agree. Wired to do it. That's why we have that magic. But no, they just call because sometimes that test, and when the MUDs first started, they didn't have really good regulations around them to make sure that they had their notices readily available and accessible by database. Well, think about it. We didn't have databases when they first came about, so.
Well, I'm just thinking, until we got that form that, talks about websites, I mean, oftentimes it was hard to find HOAs, right?
Well, HOAs aren't gonna be on the tax with it, so you're right.
So that's why I was thinking.
We haven't gotten HOAs, I'll tell you about HOAs. Because your tax rolls.
So I'm thinking MUDs are equally hard to find.
MUDs were harder to find, now they're not, because they're beyond your tax.
Right.
Yes.
There have been times that I've seen an extra tax district or special district in a tax record. That it'll say 0 for the rate, 0 for liability. And it's one where maybe it's paid off, that they're still, I guess, reserving the right to fire this up again in the future. Is that still something that is disclosed? Because I've actually called some of the municipal districts and they'll say there is no liability this time. Okay,
But they can gear it up again.
I'm assuming.
I have an example of that.
I don't have the answer.
So
And I
if
told
it's
you, we're not
0,
having the answer on this. The whole intent of this statute is to disclose to a buyer of the tax.
Just disclose.
That they're gonna have a lien on the property. All of these HOAs, that there's a obligation. It is a lien on the property. If you don't pay it, it's foreclosable. So that's the whole purpose of all of these disclosures. That it's not that, hey, you're gonna have to pay extra for your house. These are liens that if you do not pay, you can lose your property. It's just like your HOA. This is a mandatory homeowner association, that's in 62. This is a mandatory homeowner association, there are gonna be dues and assessments. If you don't pay them, you can be foreclosed. All of that is to protect the consumer from foreclosure. So I just don't know, the whole intent is tax. If it's been paid off, because a public improvement district could be paid off. It could be for underground parking in this shopping area. Of course, if it's to commercial, we don't have the biggest word, but if the neighbors around it are assessed on it, then yeah, you have to do it. But I think if the tax is gone, that's not the issue. But if you're saying they could reinstate it without, I don't know. I didn't see anything in the law that said. Yes. Mark.
I want to take it one step further, because I announced everyone yesterday I'm teaching a couple of classes on these. The
I need
reason
to
these
come.
muds and pits are out there is because the towns, oh, okay.
Boundaries, Mark,
That's right.
boundaries.
For production, the reason these muds and pits are out there is because small towns do not have the financial resources to put in the streets and water and developments. So in Anna and in Salina right now, that's all you're seeing is pits and muds and what have you. There's not a tax base in town that can afford to put in the streets and water and all that into these developments. So the developers are establishing these pits, not the town. The town's approving it, but it's still the developers. What happens 15 years later? And that was the issue here in Coppell. Coppell was 60% in a mud. Coppell couldn't afford to put in these developments, put in the streets and water, what have you. So we had this massive mud district that weren't being maintained correctly. So all of a sudden in Parkwood, off of Samuel Boulevard, it's one of the locations, people were having their sewer back up. Sidewalks were cracking, all that type of thing. The city of Coppell was given notice that in 1 year, we did not absorb the mud, that we couldn't develop anymore and the problems we were going to have in the mud district itself. So over a period of time, Coppell and that absorbed it, took it in. Our tax base was expanding because of the west side when we took it in. But we had to stop all development in the city because we could not approve any more building permits. We couldn't afford any more homes to come in with that. So that's one of the things I want to talk about too, is we're selling these far off little towns. And who's going to maintain these districts 10 or 15 years from now too?
And that's interesting, and Mark and I were talking about it, actually, when I did the research, I found that Park Cities has a mud district in Park Cities, and nobody ever knew about it, but the city has absorbed that, the city pays that, and it's billed to the city. Of course, they're passing it through on our water bills or whatever we're doing, but when it's taxed to the city, then that wasn't a disclosure that had to be done, even though it's out there, it's not taxed. So. Don't ask me any more questions about that. And Mark, I'm coming to your classes. Okay, you really can, but I'll go back to, and just be aware, so that the video that came out yesterday is frequently asked questions on this. And really, the main thing was kind of about that addendum. No, if you get, so let's say you're the buyer, you represent the buyer, and your seller hands you a different form of the notice, they've still done it as long as it meets all the elements of that addendum. So don't go back and say, no, you've got to put it on the right form because this is a true form. Secondly, the question was, hey, this contract isn't even effective. It's got 11/8/2021. And I have had people who are very observant say, Don, we can't use this, but I can't find the other one. Well, there's a reason why you can't find the other one. And yes, you can use this as approved. But also I encourage you to just look at it. That was really 67. One other change was made under the residential service contract, only to say, because before it said, and another residential service contract from a company licensed by TREC. The residential service contract companies don't have to be licensed by TREC. So they took the license by TREC out. Other than that, and adding the addendum to paragraph 22 where there weren't any changes. But if you want to make comments, I probably will make comment. I don't like the addendum, but I already brought that to the attention of one of the lawyers on the broker lawyer committee. And they said, well, we disagree. We think we need to add the MUDs as addendums. You're going to have 5 or 6 or 7 addendums. So I'm not sure that's a real good idea. But having said that, thank you for comment. I'm never shy about giving my opinion. So just wanted you to know, and so really where it was required, the change was required was in 67. So you can go back and look at your old contract to the new, that you cut the new contract. Okay, moving to the property owners associations. Remember, I'm talking single family, and if I slip and say HOA, please understand, I'm talking single family. I provided you a copy of the draft of the actual new addendum that you're using. So even though it says draft, the only reason I wanted you to see it is because the draft shows you what the changes were versus seeing the regular one. So in April, this one became the mandatory, last April, this one became the mandatory document. And what you see, and I think this is what spurred so much confusion out there in the industry. If you see, there was a paragraph D under this addendum that simply said that buyers shall pay all deposits for reserves required by the association. Period. All right. Evidently, comment from the industry and the commission and the broker lawyers felt that that was unfair to the buyer because they didn't know what those were. They didn't have an out on the contract if they were more than what the buyer wanted to spend on these deposit reserves. And for those of you who are familiar with these property management companies, they keep adding to this without control. The road managers. So broker lawyer committee, instead of, because you can't do broker lawyer, you can't bring them in, all you can do is rewrite the contract to try and help protect the parties, decided that those deposits for reserves, since we don't know how much they are, shouldn't just be automatically a buyer's expense, but rather let's negotiate who pays them. And so they rolled those back into the negotiated fees, which is under paragraph C. These have always been the fees that were negotiated between buyer and seller, and these were the fees associated with the transfer. And we've always been negotiating this, and what we had a tendency to do is cap the buyer's expense, the exposure to it, because they didn't know what these were. And we made the seller pick up the remainder. Well, that was always dangerous for a seller to pick up the remainder because he wasn't protected. But the argument is the seller's the member of the homeowners association, so he should know. Have you ever had sellers that didn't know what their management company was going to charge? I'm not sure that was ever produced in a meeting. So, I mean, they just charged what they wanted to charge. So, fast forward to this is once those deposits for reserves now came back under this, there was lots of discussion out there in the field. Partly, I'm going to suggest to you, if you didn't pay attention to that change and you represented a seller that you were fortunate enough to have represented them when they were a buyer 3 years ago on that same piece of property, and they come to closing and they see this deposit for reserves on their ledger as a seller, and they go back and say, wait a minute, I paid these when I was a buyer, how come I'm paying it now as a seller? It's because you didn't catch the fact that you capped the buyer at the traditional 100, 250, and the sellers ended up paying. Does that make sense? So it kind of highlighted some of the problems that we were having with the homeowners associations going rogue on us. And I don't mean homeowners associations, although really, yes, because now they've done any of them that have 60 or more properties in it. Hayes got caught in hers, 60 or more properties in it for a homeowner association, you're self-managed versus going to a management company. But really it became the management companies that we were trying to rein in because they just started charging unbelievable fees. So your Texas realtors did a really great job saying, enough is enough, stop it, we're gonna do this. They passed this bill, unfortunately, and I don't mean I'm an arbiter of this, but I have focused on this for so many years. You've heard me talk about HOAs and my problems with them. You would have understood this. I didn't get active with them. But when it did get passed, Lori Levy, who's your general counsel of Texas Realtors, asked me to do a webinar with her. And I said, hey, you missed a few things. I wish I'd been there, but to get legislatures passed to regulate management companies was a miracle, if you know what I mean. They have a huge lobby and several people own them that are down. What they did is they capped the fee for providing subdivision information. That is the CCNR's bylaws and resale certificate. They capped it at $375. Now, that may sound big, but not when we're getting $750 to get this. And guess what, guys? All I really need is a resale certificate. I don't need that other stuff because you're gonna get it from me for free. Because the CCNRs and bylaws are recorded of record. They're Schedule B items. I have to give you those. So all I need is resale certificate. But they can charge whatever they wanted to for that fee. So they have now capped them at $375. Some of the danger with capping at $375, there were still some homeowners association that were only charging $350. Guess what they're at now? $375. But what they missed is, I said, did you cover expedited or demand fees? Because what the law does is it says you have to answer this within 10 business days of the request, and the request has to be accompanied with the payment. If you can provide the information within 10 business days, then you can charge or collect that fee. If you can't provide it within 10 business days, then you don't have the right to collect the fee. You still have to provide it, you just don't have the right to collect that fee. Well, the problem is when we put a due date, when we order this information and we put a due date that is earlier than 10 business days from the day it's ordered and the credit card is put in there, I can charge an expedite. And we didn't cover that in the statute. Ron Walker, I did the webinar with me for HAR on these new HOA fees, and he actually commented his property is in a property owners association. And they did it differently than just charge an expedited fee. They actually said, okay, you can order it. If you need it tomorrow, we're gonna charge this fast delivery fee, kind of like if you order something online. If you need it a day, you get this fee. If you'll let me do it the standard delivery 4 or 5 days, it's this fee. If you'll let me get it in 10 days, we won't charge anything. Well, he wasn't in a hurry, so he says, I don't need to order the rush fee. He got it the next day. It doesn't take that much to do it, but they're charging us $70. So having said that, they didn't cover the expedite fee. The thing that really is good, in my opinion, and it's only if you do it the way I want you to do it, is they did cap the updated resale certificate fee at $75.
So after 90 days, you have to update.
Within 6 days, 6 months,
I'm sorry.
180 days. And that's under paragraph 3. If you use paragraph 3, meaning you have to have ordered it to begin with, okay? So you can't just do a resale certificate. A lot of people talk about resale certificate. You can't just order a resale certificate. You have to have ordered this subdivision information, even though you're gonna get the bylaws and CCNRs from me for free. You have to have ordered it, but then you can get an updated one with 75 days. So if your seller orders the subdivision information during his listing period, and assuming, so I know this is a big assumption, but not really in our market right now, assuming your property is gonna sell within 6 months. You order this subdivision information during your listing period, and because you don't have a contract, you aren't lured into putting in a buyer name on this, so that when they send you the package, they put a buyer name on it. That's what the homeowner association students do. And you do not have to have a buyer to order this information. In fact, it's irrelevant who the buyer is. Is your seller's disclosure notice dependent on who your buyer is? This information is not dependent on who your buyer is. It's a condition of the property when you order it. So it's irrelevant who the buyer is, but they usually put that in the field for you to fill out. I put the seller's name on it. If the seller, title company, or listing agent order it, you not even have to have a contract. Unfortunately, there's a provision in there that says a purchaser could order it too. We've allowed that. That's actually A2 on your addendum where a purchaser orders it. Only under that provision in the statute that if a purchaser orders it from the management company, they can ask for evidence of the contractual right. Where we're seeing some abuse right now is they're asking for a copy of the contract. I think that is a violation of privacy and confidential. And it really bothers me because your management companies are getting huge. And they're asking for a copy of the contract, whether the seller orders it or the buyer orders it. And guess what kind of database they're creating? An MLS database. We should not be giving them copies of the contract. So when I have a buyer field in and I'm ordering it from a seller, title company, or listing agent, I just put the seller's name in again. Because if you put the buyer field, they put their name on it. So even though it's the same information, if that contract fell through and you had a new buyer, they don't like the fact that it's got a different buyer name on it. They think it's certified to them. You don't do that with a seller's disclosure notice, do you? You go back and certify it for every buyer? No. So it makes me mad that they do that, but that's one of their issues that they have. Having said that, if I ordered it during my listing period and I had it, I would do it like I did a seller's disclosure notice. Don't you do that at some point in time before you execute a contract? You might have to list, but you might then have to do it. And they do it and they give you a copy and they give you a copy and they give you a copy, right? And if you give it a copy ahead of time, look at paragraph A3, where it says buyer has received this ahead of time. Buyer wants or does not want an updated resale certificate. Seller will order it, buyer will pay for it, $75. Buyer only has the right to get out under 3 if he ordered or updated resale certificate and didn't get it. There isn't just buyer has the right to walk away within 3 days of receipt. A1 is an option, right? A free option, as a matter of fact. Buyer doesn't have to pay for anything, they get to walk away. Now, fact FAQ, I should have brought this because I've got my video already ready for next week and it's on HOAs, on FAQs. One of the questions I always get is on, and this is weird, but I'm going to tell you this. If the seller has 14 or 15 days to get you the HOA information and the buyer has 3 days to terminate it, a lot of people say, well, my buyer's going to terminate the contract. Can I just go ahead and terminate it now? If the seller has 14 or 15 days to get it for you, you really don't have the right to terminate it yet. It doesn't allow you to terminate. It only allows you to terminate once you get it and within 3 days. Of course, the impact is the same because it can terminate for any reason, but you have to wait to have a valid termination. Anyway, that's just a funny comment because everybody says, well, that's worthless. I said, I get it. The other FAQ though on that is there is that 3 day on that one, as opposed to your kid notice late. If you get this subdivision information late per the contract and you haven't terminated it yet, meaning you didn't terminate it because it was supposed to be here 14 days and you haven't gotten it yet. If you get it on the 16th day, you only have 3 days from receipt of it to terminate it. You don't have till the end of the contract. So, because you kind of waived the right to terminate if you didn't get it in time. So now you only have 3 days. Okay, does that make sense? So I kind of got off board, but.
So if you
I'll go back to
if
3.
you do A3, the buyer doesn't have the right to terminate.
Yeah, under A3, you don't have the right to terminate. But under B, so look at B, but B applies to A1, A2, or A3. You look at B. If there are any material changes, a material is a legal term, to the HOA information, from the point of when you got the information to the time you close, seller's supposed to disclose that, and buyer has the right to terminate the contract for material changes, and that's a legal term. So it's not just for any reason. So if your dues just go up by CPI, or you have consumer price index, 2, 3, whatever %. If like your homeowner association got involved in a big lawsuit and they were subject to super liability, that might be a material term. But it's not just a free look. And you have that whether you've got the documents under A1 or A2 or A3. But A3 does a lot of good things for you. One, you didn't have an expedited fee because you didn't have a due date on it, so you don't have an expedited fee. And the updated resale certificate is only $75. The importance of that cap is when we have ordered updates under this before, they've charged us the full fee. And when I called and challenged them, I said, no, the statute said you could charge a reasonable fee for the update. And they said, well, that's just my reasonable fee. So I didn't have any control. So basically, if you checked 3 and you ordered it during the listing period, you're gonna order it all over again anyway. Now they've capped it, now it's $75, which is great. Remember though, paragraph 3 only works if you order the subdivision information within the last 180 days. If it's over 180 days. make the order. It's all
So in my 23 years of selling real estate, this year was the first time I ever had somebody terminate in that 3 days.
You're lucky. You're lucky, and I'm surprised this is when they did it, when the inventory is so bad.
I was
But
shocked.
when we were in buyer's market, we had buyers using this as their free option. They didn't pay for an option, they just used this.
Would special assessment apply and be if they found out that the HOA was adopted a special assessment?
It had to be material. I can't, I mean, it's kind of based on the facts. If there's, yeah, if it's huge and would be something out of line, that's kind of a material change. I can't give you a figure or an answer to it. But the difference is, it's not just you walk away because I don't like your pink tennis shoes.
Yeah.
That's,
I think it happened this year because of the appraisal addendum, you know, where
I could
there's a
spend
waiver
another hour.
and they're like,
I could spend another hour on that one.
I'm just
And
saying
I'm not
because
gonna-
of,
Yes,
because of the
I get
waiver.
it. They weigh the appraisal, so they're looking at other
And they're
apps.
looking for other
Yes,
apps. and
yeah.
that was-
It doesn't matter, it's an ounce. I don't care whether you have an appraisal issue or whatever. Why are you guys giving, I mean, if I was a buyer, I want an option period all the way to closing. So I can see where you want it. But from a seller's, when you don't have to do it, why aren't you getting this information ahead of time? It's like a seller's disclosure notice. Get it ahead of time, give it to them. It only costs them $75 to get an update. Go for it. Okay, now, having said that, the other thing that your realtor said, besides the cap of $375, but they missed the demand fee. The $75 resale certificate is great. I haven't seen anybody trying to get around that one yet. I'll take the other one. But now they also, with a management certificate, the homeowner association that has 60 or more lots and they're self-governed, or management companies who are managing single-family homes, must file a management certificate. They've had to do the management certificate now for a while, but now with the management certificate, they also have to file their fees associated with the transfer. So all of a sudden, it'll be filed of record what their deposits for reserves are. So they can't just add it because they want to throw a big party for their company, they're gonna add another fee. It has to be of record. And if they change it, you can change it in another homeowners association meeting. If they changed it, then they have to file their management certificate, a new one, a revised one, within 30 days of receipt of that. Well, where do they file it? In the deed records, in the county clerk. So what good does that do? Your realtors took care of you. Within 7 days of filing that management certificate, they have to electronically record it with TREC. And TREC is tasked to create a public database where you can look that up. Now, I will tell you, you still could be caught between the gap period of when they passed to increase a transfer fee or fee and when they record it or put it up there. But what we've made it harder on them to do that. Because when they have to go through the process of filing it and then electronically recording it with TREC. Now, that was effective September 1. But it came so fast. TREC was given a grace period until December 1, 2021 to create the database. And the homeowners associations have been given, particularly if they already have a management certificate in there, they don't have to update it until June 1 of 2022. So it's effective now, so if they need to file their management certificate, and to answer your question, Kay, I don't really have a good answer because they haven't filed one yet. But if you've already filed one, you don't have to hurry up and file one, you have to get them all updated by June 1, 2022. But it is a good future experience. Having said all of that, I've told nightmares about working with, and I'm sorry I'm picky, but this is because what? Property owners associations, we have several issues. They always demand a copy of the contract, I always refuse it. They demand a copy of the buyer's name, and I say I refuse it. So, well, you'll just have to order it again when you do have a buyer, because we need to put it on there. I said, you do not. And I have to challenge them on every statute. In Houston, they won't even release it unless you give them a copy of the contract. They said the statute requires it, and I have to send them the statute and said, no, it doesn't. It's just painful, but one of the homeowners association we had when we ordered the update, he charged exactly the same fee that he charged for the subdivision information. So I literally called him. I said, wait a minute, all you did is show me that you paid the dues last month. He goes, yeah, but I don't care. I'm an attorney and I charge $250 an hour, so you're gonna pay $250. Then we had one that gave us past dues. We ordered a dues statement from them, that which was in the resale certificate, and it showed all these past dues were there. But the property had been foreclosed on. And so the bank who foreclosed on it said, Don, look at that. And I said, oh, I'll call them for you, because the foreclosure wiped out the past dues. So I had to call the homeowners association, said that foreclosure wiped out your past dues. They go, oh, yeah, okay. But I needed a statement from coming forward. So from the date of foreclosure to the sale, they did dues. And I said, and I'll need a release of lien to file this, did on this. And they said, okay. They sent me the new due statement, which was fine, but they sent me the release of lien, and they charged $5,000 for preparation of the release of lien.
Wow.
Cost me $50 to prepare one point.
No, they love.
I was gonna say, it should be legal.
That's all they are.
I don't know. I think if the seller wanted to bring a lawsuit for $5,000, he might be able to. But you see what I'm saying? When people said, rein in these management companies, and I said, the only people who can rein them in are the homeowners who own the properties. And I said, they should be doing this, but they really don't care, because now they've got a management company running their whole thing, and their dues didn't go up because they made so much money off this stuff. Okay, so
Who
fast
owns a
forward
lot of
to
those management companies?
What?
Earlier, who owns a lot of the management companies? Is there corporations that own, and they're backed by attorneys? and they
Well,
conflict of
you
interest?
too can find that out, I'm sure. There was one legislator, he's not down there anymore, but he has one of the larger ones down there in the legislature. But far be it from me to name names, because one time I got a call from a woman that I thought, because I have been talking about this for a long time, and we had a legislative bill passed about 5 years ago that I had worked on to pass. And so the TLTA kept sending me the questions from the homeowner association. Well, I thought this one was the lobbyist for the associations. And she calls me one time, and I am just livid about what the association is doing. Have you ever heard, make sure you know who your audience is? 30 minutes into my conversation, she says, Dawn, I'm the president. Da, 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 da. And I'm like, luckily, I missed my turn off, and I had another 20 minutes going back, and I spent the whole next 20 minutes going, well, I really was meaning this. So it's a problem, but they have the right to do it. So how do we rein this in? And if I had time, I'd tell you the history of the bill and how it came, but I want to.
Is it disclosed anywhere who owns it, and if there's a conflict of interest?
Yeah,
because they're the
yeah,
lobby?
you could get that somewhere.
And I mean, it's that.
It doesn't
Conflict of
matter.
interest because the owners.
John Corona owns Associate. When this bill came out, there's a lot of unintended consequences, and Mark could testify to that. There's these bills that come out that were done for a particular purpose, but there's some opportunities within them that some people can see. From that date that bill was passed, he's become very wealthy. And I'm not saying he's wrong. Don't get me wrong. I hate to say this, but I do pretty well in my business. I'm not as wealthy as he is, but I do well in my business. And I mean, everybody has insurance, but you need it. So anyway, back to the thing that I'm having problems right now. My problem is September 1, cap 375, right? So now I'm expecting every bill at 375. Didn't cap a demand. So I get a bill in the other day from a homeowner association. And what they charged was $375 plus a $275 transfer fee. So that was what, $650? Plus a $355 demand fee because it was due before that deal. And then some other little things. We got the demand fee waived. We said that this don't need it, so just get that out there. But I said, but wait a minute, the transfer fee is not due until the property transfers. So why are you making me pay for it now to get that information? I said, well, too bad, we charge it, you have to pay for it up front. And I said, well, what if it doesn't close? Well, if it doesn't close, we'll refund it, but they're gonna have to request it. Then, what I didn't follow through with is, okay, what if if nobody really requests it, what if I have a new buyer and you guys make me order it again? You guys don't use the old information, you just check A1 again. So we order it again, they charge that $275 again. Can I say, wait a minute, and am I gonna remember, or are you down at another title company? Remember, transfer that $275 to this deal. So I get mad at them, as you can tell, but mad for several reasons, more than that. If you did the resale certificate ahead of time, like you're pointing out, if you ordered this during the listing period, you'd avoid your expedited fee. The next thing is you would also have your transfer fees. They have to say what the transfer fees on the resale certificate, they have to say that. So you would know that whether it was in the database or not, so you would have that. You would also know if there are any violations of the covenants and restrictions, because they have to put that on the resale certificate. Now, we don't have a place to find that otherwise, but I can hear your wheels turning on the seller's disclosure notice. Isn't the seller supposed to disclose if there's any violations of covenants and restrictions? He is, yes. And what I'm talking about is they need to paint the fence, they need to fix the cracked driveway, they need blah, 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 blah. The problem is the seller may not know, because the homeowner association hasn't sent the notice out yet. Because the homeowner association has to disclose it on the resale certificate, or they have some ramifications if they don't. That oftentimes is the first time that the management company goes out and inspects the property to see. So if you've ordered that resale certificate after you've executed the contract, so the seller didn't know, so it's not on his seller's disclosure notice. And now it comes in on the resale certificate, which is after the option period, and it shows that I have to paint my fence. Most of you think the seller has to fix that and bring it in compliance. There's nothing in the contract that says I have to fix that and bring that in compliance. So can the buyer require him to paint that fence? I don't know. Wouldn't I have rather known that during the option period or on the seller's disclosure, so I can have negotiated that if that's important. Different markets have sellers react differently. You know, in a buyer's market, of course, the seller's worried that you're going to threaten, so of course, it's going to have to paint the fence. In the seller market, when he's thinking he can get a better contract right now, if he waited just a little bit, he's not going to paint the fence. So I'm just saying that there's lots of benefit besides just not giving a free option, getting this information ahead of time and giving it to the buyer. One of the things that the homeowner associations did, bylaw, the one that I passed, tried to get passed by, I got passed 5 or 6 years ago. We required the homeowners associations or the property management companies to put on their website, if they had a website, their CCNRs and their bylaws, so that a buyer could read them, because many of them, some of them are like 600 pages long. And the contract only gives you 3 days technically to review them. So I always say, well, get on the website and get, because by law, they have to post on the website. I didn't know until I was doing a class in Houston that this is one of the tricks of the homeowner association, is they have them on their website, but they password protect them. So you have to pay. You have to.
Even for the homeowners that are already paying?
Well, I don't know. The homeowners probably have their own passcode.
Okay.
But I don't,
So I tell my seller, you gotta get that, you gotta provide it.
I would want to do that too. I don't know. They might have it that way too. I don't know. All I know is when I heard that, I did the same thing. You have got to be kidding, because when our thought process when we passed the statute to make it available, it's public record. It's just, you're not going to go to the county clerk and pull it yourself. You're going to wait till the title company pulls it and then gives it to you. And no, we are not in the business for doing pre-title work on your listings. A lot of people are trying to get us to do that now. Actually, that's a violation of TDI, because if that listing doesn't close with us, I don't have a good faith order for a title policy. So I'm not supposed to be pulling this. That's the thing of value for all business. Anyway, having said all of that, we tried to make it easy and they didn't.
Agreed. I mean, I understand it's weird. They live in a capitalist society, more charge, but it just sounds just so unethical.
Well, the intent of what we were trying to do then got circumvented. And that's frustrating because everybody knows what the intent is, but then it means we just gotta go in and tweak that. Just like when I was talking to Lori Lee, you didn't cover expedited fees on this, you know, so.
$5,000.
Nah.
So what does the future look like as far as that goes, as far as trying to regulate that? Is there gonna be-
Luckily, the realtors did a good job last time, and they're already got a task force, from what Lori said. Dawn will call you as we get rolling on some of this, because they just got it passed. So they'll be working on it, I'm sure, some more as they see, because I sent to Lori, I sent this bill to her, I said, see, look how they're trying to get around this. So I'm sure there will be some tweaks. I was laughing because I was doing a legislative update because we have a lot of bills that affected the title industry this last time. You know, when all our underwriters were talking about it, we talked about, because of COVID, we thought the legislative session would be a little bit slow. But I think now what we're realizing, because they didn't have lobbyists in their way, they got a lot done. So I'm learning all sorts of different things after COVID. I expected one thing and this happened. Did you expect your business to boom like it did? No.
Don, do you see A4 used very often in Houston?
In Houston, a lot, what they do is the sellers demand that you check A4, and then you check the box in paragraph D, where it says, where it says the buyer or seller pays for this information. That's another problem. The HOA used to be, we could get a statement of dues, what I call a statement of dues. It just told me what the dues were and we close on it. So if you didn't, but the resale certificate, I can use a resale certificate, but it's much more than I need. I don't really need all of the financial information. I need the dues. So if you didn't get a resale certificate, then I needed at least to get a statement of dues from the homeowners association so I could close it. So paragraph D was intended for that. If you didn't get a resale certificate that I could use, then I needed a statement of dues. Unfortunately, the homeowners association has, if I even ask for anything, demand that I ask for the whole thing, even though I've got 2/3 of it. I already have 2/3 of it, but they won't give it to me. So I have seen Houston do a lot of just in the listing, seller saying you must send that, check that waiver, and the buyer pays it under that. It gets rid of your option, and then it was that. But I'm not a big fan of that waiver, mainly because I want the seller to disclose. And I don't want to look like I'm hiding anything. Plus, under that, then the buyer's not, if I do have a homeowner association that will respond like they used to with just a statement of dues, there's a lot of information that the buyer's not gonna get that maybe they should have. Does that make sense? So I'm not a big fan of it because from a seller's perspective, I want disclosure. I didn't think I was talking out.
These guys will keep it going.
I know, this is a good group. Are there any other questions or anything?
I do have, on the new addendum for the property subject to mandatory membership, in paragraph C, which is being changed to fees, deposits, and reserves. Traditionally, agents have been putting in a transfer fee amount in there ranging between $300 and $600. What advice should I recommend to my clients as far as a number to put in there if I don't know the deposits and reserves?
Remember you're capping for the buyer. So depending on, really the seller's agent, someone needs to pay attention to this because the seller supposedly to know what these fees are, and we've already said he doesn't know what those fees are. And so that's the problem. And that was the problem. We kept seeing people putting in, capping the buyer at $250, $300. And then the seller had these unbelievable fees. And you said it just like everybody's saying, this transfer fee. And I said something about a transfer fee earlier on this bill. You have to understand, these are all fees that are charged because it transfers. But it does not cover fees that would otherwise be due, whether it transfers or not. And the way I have to explain that is because sometimes the homeowners association sends, when they have a new buyer, they want 2 months prepaid dues. But that's to pay the first 2 months. It's kind of like a bank wants you to go ahead and pay this month, and then you don't have to pay. So it's not a transfer fee because those dues would still be due, but they're asking the buyer to pay. But it would be a 2 month reserve, so they just leave it in the reserve account for future improvements. So it's any fee that would be charged because it transfers. So it's really hard because they call it so many different things. And the problem is in fact, I've gotten to send an article into because your association, your realtors, and asked us to do a newsletter for title companies, because title companies are confused. What fees are charged to whom? How do we allocate this on the closing statement? Because the homeowners association sends us this bill, and they send us, we think the buyer should pull them, say, here's a buyer bill, here's a seller bill, here's a buyer bill, here's a seller. And so some closers just charge it the way the homeowners association sends it to them. But the contract is what controls. And the contract says any fees associated with the transfer, meaning if it doesn't transfer, these fees aren't charged. Those are what's negotiated under there. And those are capped for the buyer and seller pays their remainder. So that was a long story to tell you, I don't know what to put in there. But if you feel that the buyer should pay all the deposits for reserves, because they're actually for future, you got to calculate how much that is. And you got to put it in that paragraph that they'll pay these fees up to this.
By ordering the resale certificate in advance, will that help us?
Yes, absolutely. But also will this TREC database, because the transfer fees have to be in it. You could get caught in the gap filing fee, but that's where they were trying to help you, where your association was trying to help you by having TREC create a database that had to be, and people had to electronically file that. So they were trying to help you with that. In my opinion, if we just order these during the listing period, but I've been preaching about this for 10 years and nobody wants to order it during the listing period.
Yeah.
Or in the lease, if you got it at the last transaction and it fell through, don't reorder it. Use that information. But because the resale certificate sometimes says this is good, only good for 60 days, that is a misstatement. And in fact, that woman that I was reading on in the car, and then I had to spend 20 minutes to apologize for reading it back. I said, you guys put on the bottom of your resale certificates, this is good for 30 days. That was way back then. This is before we had the 60 days. Oh, that's illegal. Dawn. We don't do that. I got back to the office and I pulled one of hers and says, this is good for 30 days. That doesn't make you think you have to reorder it every 30 days.
Yes, it does.
Really what that means is this may change, just like a seller's disclosure. If you have something new that happens, it may change. So there were dues this month. Now we haven't paid it this month. That's not, but now it's 60 days. I say 60 days. And again, it indicates to you that you have to order it every 60 days. No, what the law says is if I order it today, they cannot give me information that is older than 60 days. And the law says if a resale certificate was issued in the last 60 days, they have to give me a copy of it if I request it. That's the 60-day rule, but they mislead you by the way they write that. So it's 180 days, you can get an update.
I have one going on right now, and I put in that thing that the buyer will pay up to $100 of a transfer fee, and then it has.
The fee associated with the transfer. What does it say?
Pay any and all association fees, deposits, reserves, and other charges associated with the transfer up to $100. So the transfer fee is $150, but there's a working capital fee of $500. Does the buyer still pay the $500 that the working capital?
Where do you
fee?
see that?
That's in the thing that I got from the title.
Where do you see that in the contract?
I don't see that in the contract. That's
So
what I'm
no,
asking.
your
How do I
buyer
answer it?
should have only paid 100
Right.
and the seller pays the remainder. And your title company charged you 500 on the working fee?
They're going to, we're not
You might
closing till next
challenge
week. I've asked about it and they've written me back and said, no, it's a buyer fee.
And ask them where they got that. If say they got it off of and that's why I'm having to write the article for our dateline, for our industry dateline, because title companies are confused. The reason they're saying no, it's a buyer fee is because the homeowners association said on the bill that way.
So how should I challenge them?
Say, read the contract. And the bill is $100 finance paid, any other fees that are associated with the transfer are the seller's expense. Okay, thanks. Sorry.
I mean, I'm happy to pasted it and sent it to them already, but I haven't challenged it.
Challenge. That's why I've been tasked with writing this.
All right, you guys have it down now?
Okay, thanks Zoom people. Hope this was helpful.
Yes.
We
very.
appreciate your business so much. I can't tell you how much I appreciate it. I have a star office right there in Capel, and a lot of it's because of you. So thank you very much.
Oh, I like that. Laura hit me. Yeah, what was my question?